Hello, everyone. My name is Marcio Kotz. I'm GetGlobal's international CEO. It's a pleasure to be here with you today for our weekly live data privacy live. And today we are going to talk about how are you dealing with the new data privacy U.S. states law. As you probably know, three American states already have their own data privacy law: the state of California, Colorado, and Virginia. So today we are going to talk about how are you dealing with the new data privacy U.S. states law. We are just going to wait a little bit so everybody will be able to join us. So we are going to start our live in a couple of minutes. Okay, guys. So once again, my name is Marcio Kotz. I'm GetGlobal's international CEO. GetGlobal International is a data privacy consulting company with operations in the US, Europe, and South America. And every Wednesdays, we host our data privacy live. Today, we are going to talk about how are you dealing with the new data privacy U.S. states law. Data privacy is changing in the U.S. and some states already have their own data privacy law. And the question is, how is your organization dealing with those piece of legislation? The next slide shows a little bit, brings some news about those data privacy legislations. More states are enacting potentially conflicting data privacy laws. There is one news from Leader Publications, as Colorado and Virginia follows California's lead in enacting data privacy laws, employers must start planning to address an inevitable trend. And the other news says that new state privacy laws will enforce companies to rethink data collection practice. So, as you can see, many American companies will have to change the way they process personal data. They will, first of all, have to manage an assessment to understand what kind of data they collect, what are the source of the data, or where they store the data and why they collect the data, who they share the data with. So many different things that it will require one huge amount of tasks to come up with all the gaps that the organization will have to change. But first, we need to understand how these legislation work. So we've worked in different parts of the world with data privacy, and we've seen different stages when it comes to um, a country having a new data privacy legislation. It changes the way that the society see how the organizations collect and process personal data. And these different stages is what we call the change of the culture regarding data privacy. I would say that at this point, the US is becoming more mature when it comes to these data privacy culture. And as we've seen in some other parts of the world, uh, one of the first questions in any organization is who or what department would be responsible for dealing with data privacy, or at least would be responsible for making the company comply with the data privacy, the new data privacy regulation. Because at the end of the day, a data privacy program is multidisciplinary. So that means that not only one area is going to be able to solve the whole problem, mostly because the solution for some of the gaps come from different areas. What I mean by that is sometimes the solution is a legal matter. It may be a question of changing a contract or even drafting a disclaimer or something like that. But in some other cases, it's just the way that you do something, and you should change the process to have a different legal outcome. But the change would be in a different area, maybe human resource or the operation department, or maybe the financial department. So sometimes changing the corporation process is not exactly something that a data privacy lawyer would be the best expert to deal with. Sometimes the solution of the gap may be the implementation of a data privacy software. Let's say that we are talking about a big retail chain that collects and processes a huge amount or huge volume of personal data. Definitely, that organization will need a data privacy software to help them manage all the company's obligations in order to comply with the data privacy regulation. Trying to find the best data privacy software and even implementing that software may not be something that a data privacy lawyer would be the best professional to do it. Or sometimes the solution of the gap is more a question of a corporate culture that would have to change. It's more training. So let's say that some specific area might need one specific training on data privacy. Maybe that training, the change of the corporate culture regarding data privacy matters would be addressed by some other professional in a better way than it would be by a data privacy lawyer. So what I'm trying to say is that it's not mandatory that the legal department would be the one responsible or would be the manager of these of the data privacy project development. So one of our surveys, and the next slide shows that in our last survey, we asked many US companies, how are you dealing with the new data privacy state law? And we asked what department was responsible for managing the program. And most of them said that the legal department was responsible for the project. Some of them, the responsibility was over the compliance area. And for some other organizations, they decided that information security would be the right ones to take care of it. As I said, we've worked in different parts of the world. I have managed more than 200 data privacy projects and helped more than 200 organizations to comply with data privacy regulations. And I would say that in many other countries, information security might be the department that was responsible for managing the project, because the legal aspect of it could be added to the team, but the manager would be the CISO, the Chief Information Security Officer. Why is that? Because some companies think that the information security professional is more used to policies when it comes to the way that they protect information, therefore the way they may be able to protect the data. So in many organizations, they already have information security policies that were drafted by information security departments. So this professional is more used to this multidisciplinary kind of project. And they would be able to manage the project, understand the needs with a legal support. But in fact, in the US, many of those projects are seen by the company more as a legal issue. But for sure, those corporate lawyers would definitely need assistance from different other areas to deal with some things that are not 100% a legal matter. And why is that? The next slide shows how one of these state laws work. The new state laws, California, Colorado, and or Virginia, they define what a personal data is and also describe some new obligations to the organization. Most of those obligations will be executed by other departments than the legal department. So those departments, they need to be aware of the things they need to change in order to comply with those legislations. So in some cases, right from the beginning of the project, they really to understand what the challenge is, what are the obligations, what exactly we need to achieve and solve. As I said, they need to manage an assessment so they can understand what are their gaps, and they need to change either process or corporate culture, or even implement some data privacy software. And sometimes the solution is a legal matter. So as I said, it's not mandatory that a data privacy project needs to be managed by the legal department. Probably the legal department won't understand the impact of changing different processes in the organization, and probably they are not most of the time qualified in finding the best data privacy software when it's needed. So I think that the survey shows that the US is taking the same path that other countries did. There is no right answer for this, but all the three departments that we heard from the people who answered the survey are the departments that in other countries were the ones responsible for managing the data privacy projects. So we've seen in the US pretty much what we've seen in some of the other countries or when there is a new data privacy regulation. The next slide shows us things that we need to know about, for example, this new state legislation. So it says that the California Privacy Act applies to business that intentionally target Colorado consumers and that collect and store data on at least 100,000 consumers or earn revenue from selling data of at least 25,000 consumers. Businesses have multiple new obligations, including a duty of transparency, duty to avoid secondary use, duty of data minimization, duty of care regarding data security, and a duty to obtain consent before processing a consumer's sensitive data. So all those obligations will probably be fulfilled by some other departments than the legal department. So it could be the legal department responsible for data privacy telling all the departments what they should do, or the departments responsible for complying with those obligations would be aware of their obligations, and if they may have some specific questions, they would be able to ask the legal area. So as I said before, there is no right and wrong answer for this. There is what we've seen in some other countries, and I'm telling you from my experience and background that what we've seen in the US is pretty much what we've seen in some other countries. That's pretty much the idea of this survey. So now the next slide, we're going to talk a little bit about what to do to prepare yourself, to prepare your organization to comply with a U.S. state data privacy legislation. First, you need to conduct a data mapping exercise, data mapping or data discovery. Sometimes the organization doesn't know what kind of data they've been collected in the past years, because until we have a data privacy regulation, the idea was pretty much to collect as many more data we could. But now, as we have the duty of data minimization, which means that we are going to only process the data that we need for that specific purpose, we need to understand what kind of data we storage. So we need to conduct a data mapping or a data discovery. Remember that there are some softwares that are able to help you with that, but they will definitely not be able to solve the whole problem, because under some regulations, personal data would be defined as any information of a identified or identifiable person. If I take the first part of the definition, any information of identified person, probably a data mapping or a data discovery software would be able to help me, because many softwares are able to identify people by their names, social security number, or driver's license, or whatever. But the last part of the definition, which is any information of an identifiable person, that changed, because it changed from different scenarios. It changed from different perspectives. In some situations, the person is identifiable. In some other situations, they might not be identifiable. So that data would be classified as personal data if the person is identifiable in certain context, but it wouldn't be classified as a personal data in some other context. And as far as I know, as a specialist, there is no software able to draft all the scenarios possible to tell you if that person would be identifiable under all circumstances. So the way that we do that is by interviewing every single area of the organization. So the data privacy team would interview all the managers to understand different things, and would be able to come up with answers of many questions that we would have to answer regarding all the obligations that we have under the data privacy regulation. Things such as what kind of data we collect, why we collect the data, if that data is necessary for that purpose, where we store the data, who we share the data with. So many different questions that we have to ask during the assessment. And I usually say that these phase, the assessment, represents something like 60% of the whole project. It takes a long time. It will need a huge analysis of the answers that will come up from the interviews, but it's very important. And that links with the bullet point here: perform a privacy impact assessment. Once we have a clear understanding of the situation, we can understand what is the privacy impact. Then if the company engages a high risk processing, then we'll have to definitely identify all the gaps so we can solve the problem. Once we identify the gaps, we need to update the policies and the procedures for compliance. Then we need to review and adopt policies in order to have different procedures to attend the consumer's right and the consumer's requests. So that's a different thing, something that we'll have also to worry about, because we now have other obligations which are the consumer's requests. So we need to be able to take those requests and reply to them within the time that the law will stipulate. We will also have to change the company's culture. So a lot of training would be necessary. So as you can see, it's very, as I said before, multidisciplinary. So definitely not only one department would be able to address all these issues by itself. But for sure, someone needs to be the manager of the project and we'll have to decide what area is going to be the manager of the project, but definitely that area won't be the only one responsible for this project. So that's pretty much what we wanted to talk about today. So I hope you have enjoyed. Don't miss our next live. It's going to be a different live with Aaron Weller. He's an American data privacy professional. He's based in Seattle with a very good background. And we are going to talk about this new opportunity for American professionals to work with data privacy. So keep tuned, and I'll see you next Wednesday. Take care. Bye-bye.